Good afternoon, everyone, and welcome to your Wednesday webinar of the Property Law Alliance. So good to be back this week. I hope that you all had a fruitful and eventful week and that you've come to the right place now to listen to our experts as we discuss some really interesting topics that we have lined up today. As always, it's good to have you, Bruno. It's good to have you, Greg, and it's good to have you, Silna. I'm going to let you do some introductions. And this time, we're not going to start with Silna, not ladies first. We'll start with Greg. Greg, how are you doing?
I'm fine. How are you, Chris?
Not too bad, man. Not too bad at all. It's better seeing the three of you as well. So my highlight of my week.
It's always fun, I must tell you.
Yeah. Bruno, how are you doing?
I'm good, short and sweet. I'll pass it on to Silna for the weather update.
Silna, how's the weather looking?
Thank you so much. I think that's why you're leaving me for last today, so I can do the weather update. It's nice and sunny and warm, and after last week's rain the whole time, it's really looking better this week. Apparently, it's going to be pretty warm for the rest of the week and the weekend, and then rain again next week. Back to you.
Okay. Back to you in studio.
Is this a fact?
It is a fact. Also, speaking of facts, fun fact, way back when I was in varsity, I had a radio show where I used to read the news and I used to do the weather. So I have some experience in news and weather reading, but it was in Afrikaans. And the last news thing I had to read, I had to use the term immunisasie program, and my tongue just went. Try saying immunisasie program. So, and then I was like, okay, maybe I'm not a news reader. Let me rather stick to law. So, fun fact about me, I had a radio show.
Good to know.
Wow, that's pretty amazing.
Which is probably why I keep going back to the weather. I'm actually a weather girl, not a lawyer.
Anyway, it's so good to have the three of you with us. I'm sure that everybody's excited as well for what we have in store. So I'm going to get straight into it because this is a very interesting question that we have, and it's going to engage all three of our experts. So let's start. Basically, this question says that there was an individual, rather, who purchased a property in a boomed community or boomed area. And the person who purchased the property transfer took place in August of last year. So that's quite some time ago. The individual then started renovating the property, not residing there, but renovating the property, keeping the necessary upkeep in terms of the property itself. And then when he moved in, discovered that there's a plot or a stand that is adjacent to the boomed community. And on that stand, there's an informal settlement being built there. So only when he moved in did he discover that the noise levels coming from this particular informal settlement had picked up over certain periods. So in the evenings, let's say, for instance, the weekends when people are trying to party or whatever it may be, and he noticed it. And obviously, he had noticed it far long after registration had taken place. Now, this particular property is owned by Standard Bank, and Standard Bank, along with the city of Johannesburg, are not too concerned with, conducting an eviction on this property. But this now has become a sticking point for the purchaser. So the purchaser is saying, hey, I didn't know about this place when I bought this particular property. And in fact, the seller was supposed to disclose this to me. This was supposed to be something the seller disclosed before because it would have changed my opinion completely on this property had I known that there was this squatter camp or informal settlement being built. So I think the question then is, can the purchaser set this sale aside so far after registration of the property? And did the seller actually have an obligation to disclose this information? So I think let's start it off with Silna, because earlier we started off with Greg introducing himself. So as ladies first, Silna, what is your take on these two questions that are posed at this point? There is a third question which I will ask, but that will be after we deal with these two.
It's very interesting. I must say, if I didn't get the first go on an answer, you're welcome to leave me for last on the welcome every time. I'll take it any day. The thing is, this is a very interesting question because it deals with so many aspects. And I think that's why I'm so excited about tonight. It's not just the weather, it's a very interesting question, because it's layered with all sorts of different elements. So if we look at just basic rules on when can you set a sale aside. First off, if we look at the Consumer Protection Act, obviously there's a 5-day cooling off period that might apply in some sales situations, not in all, but in some it might apply. But now we're far past 5 days after conclusion of the agreement, so that story is out the window. If registration hasn't taken place yet, obviously the purchaser would then be in a position to act if the seller was in breach or something like this happened. He might have been in a position to either ask the seller to rectify the situation or something similar to that. But even if registration hasn't taken place, I can't see that the activities on the adjacent property can ever be an obligation of the seller to purposefully hide that fact. Yes, that is an active misrepresentation, of potentially even fraudulent misrepresentation, which could raise a whole new set of questions. But in this particular matter, I think it's important to point out that as a purchaser of a property, you have the obligation on yourself as the purchaser to do due diligence. And something like this, what's happening on the neighboring land, isn't something as simple as the seller saying, listen, there's a huge problem. There are squatters on the property next door. At the time of the sale, it could have been that it wasn't that bad. Also, if registration took place in August, it means the sale was probably in June, July. That was pretty proper lockdown. So just before that, it might have been calm and chilled. And I'm quite sure Bruno and Greg will get into it more about how an illegal occupation of land situation can go from relatively controlled to, oh my greatness, call one of our firms. So the truth is, unless you can prove as a purchaser that there was fraudulent misrepresentation during the sales process, to try and set a sale aside is pretty much close to impossible. So I won't go into too much more than that, but I think one should never confuse buyer's remorse with fraudulent misrepresentation. And I'm sorry to be this blunt, but the truth is, unfortunately, if you realize 6 months later the neighbors are loud, you can't lay that responsibility at the seller's door. My neighbors have a parrot, and I love my neighbors, but the parrot, everybody, all our viewers would know the parrot, and the parrot is now starting to say hi exactly the way I do when I answer the phone. It's also not 100% pleasant for me, but I can't go back to the seller where I bought this property and be like, but the parrot's loud now. You know, there are certain risks and things involved when it comes to buying property. And the truth about property is neighbor law is something very real in our law, and we have a lot of case law around neighbor law. So this purchaser might have remedies towards other parties. But honestly, I can't see how the seller can be responsible for this, not in the sense of setting the seller aside, and also not in a damages claim or a purchase price reduction, something like that. I don't know. Do you guys agree with me?
Okay, let's pass this on to Bruno. Bruno?
So I do agree with you. For the sake of context, so that the viewers understand the angle that we're approaching it from specifically. Forget for a second that this is an adjacent piece of land that has unlawful occupiers in it. Let's just focus on defects, right? And let's consider this to be some form of defect to the property. So just to give everyone context, right? Our law applies very differently when it comes to different forms of defects and whether the contract falls within the ambit of the Consumer Protection Act or simply the common law. So the general rule of thumb before the Consumer Protection Act came in is you can sell a property in any condition, any state. If you mark it as footstuds, there you go, no issue at all, unless the seller intentionally or willfully hid something away from you as a purchaser. And that's what Silma's referring to from the misrepresentation perspective. It's the intent behind it. They wanted to hide it away. So, I mean, typically you'd find people that paint over damp and, that do superficial repairs, knowing that like in a couple of years, the thing's going to collapse again, but no one's going to ask any questions at that moment in time. CPA then came in and said, okay, hold on. Now you can't just sell a property footstuds. The seller would typically be liable for anything that isn't disclosed. The seller is supposed to actually hand over a property in like a good fit for purpose condition. Of course, if the purchaser and the seller agree to certain defects, then there shouldn't be a problem. The property can be transferred under those circumstances. So under the CPA, there's a bit more of a onus or responsibility on a seller to ensure that the defects are made known because they can't hide behind a footstuds clause. So now we're going to move and bring back the fact that this is an adjacent piece of land. And we start asking questions now. Now, whose responsibility was this? We also need to look in the South African context, right? It would be very strange because, I mean, people live in the Lone Hill area. They live in plenty of areas. I mean, if you go around like your honeydew areas and places like that. Now, imagine selling a property there where we know that there's a number of informal townships all over the place, right? Selling a property there and then somebody coming and complaining that they had no idea. There is an element, one also does need to look at this in relation or subjectively, right? You buy something in South Africa, there's a crime, you can't kick and scream that there wasn't a disclosure that there had been a crime at some point or another. We live in a country where crime is almost anticipated. It's when it's unusual that you need to start asking questions or that you should disclose. So if there's a spree or something crazy has just happened over a period of time, that you might need to disclose. But typically your day-to-day life that every South African experiences, isn't something that one can consider a defect. So it's a very interesting case because we're actually not even looking at whether there's a patent or latent defect. We're looking at whether this can even be considered a defect or whether it's just the normal run-of-the-mill situation where, there's a piece of land next door, it happens to be vacant, and there's people living on it. What do you want the owner to do about it? It's there. A lot of people, experience that. So even if we don't go as far as to say, because I mean, I know that very commonly things also get worse. So you buy a property in June, like Silma mentioned, and by October, it's packed. And there's quite literally in 2 weeks, you could fill up a whole piece of land. So, I mean, looking at situations like that, it's very easy to say that nothing was even there when the property was purchased. So there's a lot of different angles to consider this from. But I mean, at a very basic level, the reality is I'm not even particularly sure that this can be considered a defect to begin with, unless this was something that all the sellers or owners in that specific estate were experiencing as problematic. It became a real big issue. It became an issue that possibly even forced the seller to sell, and he sold without mentioning it. Maybe then you could elevate it to a defect. Maybe then you could elevate it to something that he hid away intentionally, and you could then, rely on it. Another thing to also bear in mind is also materiality. Now, again, it comes back down to, is it material enough for a sale to be set aside, or can it be remedied? So can somebody just cancel a sale based on this? Or, should you rely on recourse to claim damages? So it's, again, remember, because of the way that our system of property transfers work, it's not particularly easy to set transfers aside, especially if there's bonds in place. Because now you need to try get banks paid back their money. and if the money's been used up, it's a disaster. And now the other bank whose bond has been settled is not going to want to return the money to the bank that you used to. It's a nightmare. I mean, to try and actually do it practically, I've been involved in a couple of those. And it's actually so funny, the disconnect between how the courts order the setting aside of the transfer and how you're actually supposed to execute it practically. It's a complete disaster. So I mean, it happening, it shouldn't happen easily. It will probably be more a case of if damages were suffered, if there's a reduction in value, somebody lost something, maybe you could claim that back. But I doubt setting the sale aside.
Well, it's actually very interesting what you're saying, because now hypothetically, let's say the seller buys 100 by 100 square meter camouflage piece of material, goes over to the informal settlement and completely drapes it over and tells everybody in there, you guys, shh, the purchaser is coming now, just keep quiet. I just need you to keep quiet for an hour. Once he's here, he's going to buy the place, and then the next weekend you guys can party. So, is that considered to be a hiding?
I must say, I do want to grab onto that one, because it's a relevant thing. I mean, it's a little drastic, but still, I do believe, my opinion is still that the purchaser's obligation to do due diligence does extend to the point where you expect a purchaser to at least drive around the property a few times before you put in an offer. So theoretically, even if that happened, and the seller did, for the time of viewing the property, covered the shacks, even in that case, I'm still maintaining that there is a level of due diligence that would extend to the point where if the purchaser drove around the property a few times, he would have seen that, or he would have gone on Google Earth and he would have seen that. So even in your over-exaggerated example, I still maintain that the purchaser wouldn't have a claim against the landlord, against the seller. It's almost like saying you went through a property to view, and then 2 weeks later, the entire roof gave in, but you never inspected the ceiling. There was no reason for the seller to disclose this. You, as the purchaser, had due diligence obligation on yourself, or you could have asked for a time period or even a suspensive condition to allow you to do due diligence. And you would have been, you were supposed to get a property inspector out to inspect and see what the condition is. I think the CPA, and I say this with all respect to consumers and everybody else, but the CPA should never be seen as a piece of legislation to take your obligation of due diligence and practical common sense away from a consumer. Am I being the ice queen tonight?
Look, I totally agree with you. I am worried that the interpretation sometimes by certain courts does leave it very open-ended, where some courts are very pro-consumer, and then some lean back towards the way that our common law used to deal with these type of contractual situations. Because, and again, this goes back to our conversation last week on labor law, where and I think I had this conversation.
Jazz.
Labor law. There's no labor law in any of this.
But the crazy thing with it is, like, even from a contractual perspective, when you're hiring people in labor law, there's almost little value having contracts. I mean, I'm not saying don't have contracts and employment agreements, but it's just crazy how the minimum standards are set to such a degree that, for all intents and purposes, entering into an employment contract is already contracted. and to the T. Like, it's not even just implied industry standards that people expect. I mean, I'm talking about, the leave days that you get, the hours you're supposed to work. I mean, short of naming a price, you're good. Like, you barely need any employment contracts. And the CPA tends to follow suit with a lot of things when it comes to things. And the magistrates' interpretations of it sometimes lean a lot towards placing a greater obligation or onus on a seller to perform, where it starts becoming so difficult because it's so strict and you don't have a lot of room to maneuver around, which is also quite funny because when you look at sales and execution of immovable properties, then it's actually quite the opposite. I don't know how they've managed to steer clear from those strict regulations, but quite literally, when you buy from a sheriff's auction, everything goes. Like, it doesn't matter. It's everything could be wrong and you're still stuck in that contract. But yeah, I mean, I digress. The reality is that the CPA is just one of those things that is very kind of abstract and malleable to interpretation.
Okay.
If I may,
okay.
Sorry, Chris, if I can jump in.
Go for it.
It may have been a diversion, but it was. I think it's an important thing to have stated, Bruno, because the people in this community that we belong to here, it's the same with leases. It's the same with an eviction application. If there's an opportunity to interpret away from you and in favor of your tenant, the court will take that opportunity every time. It is like that.
Absolutely.
Yeah. So I want to bring in a third question, and this obviously is going to be directed towards you, Craig, and it's from an eviction perspective, and it's just with regard to the fact that this property now belongs to Standard Bank. There's a community now who apparently would be up in arms, being this boomed community, the residents who are lawfully there. Can they bring an application for an eviction of this adjacent stand or property where this land grab is going on? And because would they be successful, because this land doesn't belong to them? In fact, it's not necessarily in their distinct community or boomed community. It's adjacent to it. Can they bring that application?
No.
Yeah.
No, they can't. They won't have locus standi or authority to bring an eviction application on land belonging to another person. Now, the best mechanism in this environment, and I've used it. I've also, in the days when I was representing one of the city councils, I've suffered from it. The Section 6 of PI imposes an obligation on a municipality to evict from privately owned land in certain circumstances. So the boomed community wouldn't be able to bring an eviction application. They could request and then force, by way of a mandamus, the municipality to take that action. And there are a couple of prerequisites. One, there has to be some level of formality that's required in terms of approval by the municipality, which may be zoning, it may be enforcement of the National Building Regulations and Standards Act. There generally will be with an informal settlement, and it has to be in the interests of the community, which it clearly would be again, A, because of that very informality, B, because of, let's say, informal liquor businesses, whatever the case may be, which I understand to be part of the concern. So the conditions precedent for a Section 6 eviction on the part of the city would prevail. Then you would obviously have to, the city, on the assumption of informality, would have to itself provide temporary emergency accommodation, which will probably take some time. But they could and should be forced to take that action, as presumably could the bank. But in truth, the only real solution for a matter like this is via the municipality. So, you could cite Standard Bank as a respondent, as an interested party, and possibly by way of some kind of cost implications. But your outcome is going to come from the city of Johannesburg.
Okay. Thanks for that, Craig. I'm gonna move on to a question that is linked to this one in some respects, and it was a question raised in the group, and I'm always encourage the viewers, please post your questions. Like I say, every week we're really going to dig into them. So this is one of the questions that were posed in the group, and the question is: if I buy vacant land, whether that be in an estate or whether that be municipal property or whatever it may be, are there penalties in the sense of building penalties, or perhaps even higher rates? Now, we can take this example of this property that's owned by Standard Bank, which is exactly vacant land. So how is it that, is there these penalties that occur on municipal property? I think we'll throw this one quickly to Bruno, and then we can take it from there. Bruno, I think you're on mute.
Damn it, twice in a row.
That's why I'm laughing.
With respect to the municipality, I know that obviously with the work that Greg did, it'd actually probably be better placed to answer that. My understanding is, yes, there are higher rates. With respect to homeowners associations, I'll spend a bit more time on that. Well, long story short, if you buy within an estate, so this is now in our particular example now with this adjacent piece of land, I don't think the levies, the private levies by a homeowner association would actually apply to that situation, because obviously it's outside of the estate. So there you'd probably be looking at municipal issues. If for some reason there's a vacant land within an estate, what you typically find is that when an estate is actually established, they set certain ground rules in order to ensure that every owner's properties within that estate carry some sort of aesthetic similarity, and it's not similar market values, but that they carry each other from a value perspective, right? So you don't want certain properties to look a certain way. So they've got minimum coverage, for example, certain looks that they want to go for, and certain rules just in general that actually need to be approved before the building, before construction even starts. So one of their pet peeves is when there is no construction and when there's empty pieces of land, because funny things happen when there's empty pieces of land, including somehow somebody finding their way onto the property, hiding on the vacant piece of land. And some of these estates are huge, so these pieces of land are quite large. So very bad things happen. And then also from a value perspective, the problem is no one's taking care of the land, the grass gets long, so your property just appears shoddy. It looks cheap, right? So what they do in those type of situations is they levy what's called a building penalty. And that building penalty, basically, they say within 12 months, you need to start construction. If you don't start construction within 12 months, we're going to charge you X. And they just keep charging X. And we've had case after case when it came to this. These penalties are sometimes 3 times the value of the normal levies. And then once you take interest into account, and the fact that interest is compounded, these levies it skyrockets. So you can go from a normal levy of 1,000 Rand, building penalty sometimes 5,000 Rand. At the end of 3 years, it's a fortune. I think you're sitting with almost 300,000 or half a bar, somewhere around there. It's really, really bad. I think that was after 5 years, if I'm not mistaken. So yeah, that's one of the risks of vacant land when it comes to estates. With municipality, I don't know, Greg, if you have more information than what we discussed earlier.
No, Bruno, I think we both have the perception that vacant land is you pay higher rates on vacant land than land in which something's been constructed, and obviously it's a disincentive to keep it vacant and an incentive to build. I think we're both right on that one. Silna will be the third contributor. I'm sure you'll agree.
Yeah, I do, and I think it's actually to our first question. Actually, still, I think very often people buy land with the idea that to just hold a piece of land somewhere, something amazing is going to happen. And it's like buying a lotto ticket. The next moment you're going to hear that, you know, this group wants to buy the land because they want to develop a flamboyant mall. It really doesn't happen that often. It used to. I mean, we went through a major property boom. I don't know how to break the news, but we're not really in a boom right now, if you haven't noticed. But to hold vacant land and not do anything with it and not secure the land is potentially one of the scariest things. I think, guys, Greg and Bruno, both of you would know exactly what I'm talking about. Those evictions that's protracted on a whole new level. The evictions where we have to get alternative accommodation, we have to compel city council to provide accommodation. It never happens, or rarely happens, on land where the owner was actively involved in the land. The properties where those evictions happen is the land that's been lying. So my point is, I agree with both of you. I think your increased rates and taxes or your potentially higher levy is the least of your worries. To leave land lying is one of the worst ideas. Then at least get somebody to reside there, make a plan to utilize the land, because those are the problem matters if you leave a piece of land. And like we said, if you have one shack popping up, I can promise you in 2 weeks you're going to have 20, and then it's from there all the hell breaks loose. And it's a problem, because remember, as much as to the owner it's just a squatter, in the people, illegal occupants' minds, this is now their home. This is where they are living, and they have children and they have stuff. It's not as simple as like, this is not Sim City. You can't select all and hit delete. You have to, these are people that we have to deal with. So I think it's important for property owners to appreciate their responsibility to use their land and to secure their land. I know it sounds funny, but it's important to know.
May I add to that, Chris?
Yes.
You know, the point is that, as Silna has correctly said, vacant land looks occupiable. You know, it's people urbanize into the big cities, Joburg in particular, at a massive rate, not only domestically but from all over the continent. I mean, the numbers of households that come to the big city every year would stagger you. Now, some people are entitled to accommodation from the state, others aren't. But what will happen is someone needs somewhere to live. Maybe where they've come from, there's a high degree of informality. So a piece of vacant land looks fine to live on. And what generally happens, I've been doing this for a long time, is someone will live under a tree or under a bush, or, you know, very discreetly, because, you know, people aren't going to spend their precious hard-earned money on something that's going to be destroyed. So people live discreetly for a while, and then maybe put up a shack, and then people are watching the whole time, and then maybe it's 2 shacks. You know, it might not be in 3 weeks, it might be in a year or 2 years. 1, then 3, then 8, then 20, and then a settlement. Most occupations of this nature aren't politically motivated. Some are, and we've seen that recently in the last 3 years with the EFF and that business, where there's actively a demand, a political policy to invade land, and that has happened. And I must tell you, it's been happening since way before the EFF. Every political cycle since I started doing this in 1995 has attracted politically inspired land invasions. Someone wants to make name, maybe even a bit of money. So you've got 2 choices. You either lead an invasion of land and get cred as a leader. Next thing, maybe you've got a job as a ward councillor somewhere, or you get rejected, or you get sort of rebuffed, and you've made name because you've led this invasion. You know, the stakes are low, and the benefits are high. So we've got municipal elections notionally in June. We can anticipate we're going to get into invasion season again, especially, EFF nonsense. So, so that's going to happen now. It's going to start now. And, often what happens is over the political season, not only the politicians, the municipalities, but the police are distracted. So it's a good time to invade. It's like Easter weekend. It's the biggest land invasion time of any year. Christmas the same, but more Easter. You've got a 4-day holiday weekend invasion time. So what I've been instructing my clients to do is, especially developers who have large vacant land that's ostensibly unused, is don't fence it, because that's often crazy expensive and the fence is often stolen anyway. Put up a sign: housing development, commercial development, retail development coming here, because even the EFF are unlikely to invade property that is obviously going to be used, because everyone who puts up a shack has spent $1,000 or more on iron sheeting. People are not going to waste their money. What you find is people will come along on a weekend and demarcate. They'll get that accident tape, chevron tape, mark it out, clear the bush, sit and watch. No response. Next weekend, some more. No response. Next weekend, maybe a shack goes up. If there's a response, it mostly goes away then and there. So if you own land that is vacant, and I hate to say it, put up a false sign. If you're holding it, for some future indeterminate project, put up a sign saying housing coming here or something like that. It sends the signal it is not vacant. It sends a signal it will be defended. It will be protected. If you waste your money and put up a shack, it's going to be destroyed and you're going to lose your money. People won't do that. It's only the hardest core, politically motivated land invaders that will go that far, that they'll actually waste their own money in doing something like that. But defend it, send the signal, make sure that everybody knows, anybody who cares to look knows that it is not vacant land. The other point is municipal or state-owned land is much more vulnerable than private land in any context. And the problem is where you are in the sort of Zandspruit area, for example, where there's a lot of state-owned land, but a lot of privately owned land, it's difficult to determine. Send the signal. This belongs to Solna. Solna's land. Go to develop it. Go next door. Go somewhere else.
Okay. I think one question I would like to ask, and we don't have to go too deep into it, but this strategy that you're talking about, Craig, obviously is going to be far cheaper than having to deal with an eviction of obviously 100 people or more, whoever it is living on that property. How difficult is it to get an eviction order granted? How long does it take, and how expensive is it? If, for instance, I didn't take your advice and I just left it.
That's a very, very good question, because if you're dealing with a live invasion in a kind of reverse trajectory, a live invasion you can stop. You don't even need an order. You can get security, ask the police to come and assist you, and you can stop that invasion. The problem is, in truth, confronting a determined invasion is a very dangerous activity. We've all seen the ugly events over the last years and decades when someone gets clever and someone starts shooting. That's not an outcome you want. Ideally, you want the forces of the state, be they the police or the sheriff, the municipal police, to stop that kind of conduct, because trying to do it as a private person, as a private country, is A, very expensive, and B, very, very dangerous. So it's this Saturday. You own a piece of land, 10 hectares of land in Johannesburg somewhere, northwest Johannesburg. And suddenly you hear that people are invading your land. Your first instance is to look for a spoliation order. You will run to court. You will get an order interdicting any invasion. So the first thing you do is you get across there, the sheriff, the police, anybody, say, hey, we've got an order, you can't do this. Now, the moment that invading community understand that there's an interdict against them, they can't claim that even throwing their sleeping bag on the ground will constitute their home. Because now you're in a race between the occupation and the ability of an occupier to claim it as their home, and therefore get into the long spin of PI and alternative accommodation, etc., etc. So that's the first thing you do. You go back to the urgent court on Tuesday, which is the normal urgency day, and you say, right, I got my interdict on Saturday morning. Sunday, 20 shacks came up. I want them off. The court will grant a spoliation order. They will not need to go through PI, because this is an invasion. There's no way in any circumstance that they can claim that this is their home, because in the face of an interdict, in the face of resistance, they put up a shack. Spoliation, no problem at all. Right, now it's next weekend, and there are still 20 shacks there. You haven't done anything, maybe. Now it's on the cusp. Now you don't know, must I bring an eviction application? Must I bring a spoliation application? What we've generally done in these circumstances is bring them both in the alternative. A Section 5 eviction application, which is the ultra-urgent mechanism where there's a danger to life or property, and you will get that order. Even if the court is reluctant to give you a spoliation order after a week or 10 days, the court will give you a Section 5 ultra-urgent order, because, again, they've been there for a week or 10 days. It's not their home. They lived somewhere else 10 days ago. So the normal dangers of homelessness don't yet apply. The problem, of course, now, the moment there's a degree of permanence, and the moment that someone can legitimately claim that this is their home, and it's not necessarily linked to time, but obviously time's a big factor, then you're into PI. And it can get expensive. Look, in truth, now that we're talking about the cost, there's no real opposition to an application like this. There's no meaningful defense, excuse me, to this kind of eviction application. The problem is time, because people live in shacks. The chances are very high they're of the most vulnerable demographic, and therefore can't be evicted without the municipality providing alternative accommodation. So you run the real risk of time. You run the risk of waiting a year or more for the municipality to be able to find temporary emergency accommodation. So that's your real risk, time more than money.
Wow.
Greg,
Wow.
Greg, if I can interrupt, I think the point you're making is absolutely beautiful, because what we always see is the owner will call to find out what it's going to cost. Now you have to quote urgent fees to get to court on an urgent basis. It is expensive. It is expensive, because we have to run to court on a Saturday morning. It's going to cost you more, and it looks like a huge number. But I think what many landlords and landowners doesn't understand is to leave it isn't going to make the cost less. It's going to make it worse. And now you're losing opportunity costs, and you're losing property value. And I think very often I've seen so many matters which I know we could have resolved on an urgent basis, but the owner was reluctant to give the instruction, because why should I pay for this? Well, you're going to pay for it anyway, but now it's going to take you a year to 2 years, because we have to get the municipality to go into the inquiries and see where they can find land. And it ends up not just costing you more, but to your point, taking much longer. So I'm very happy you brought that point up, because I think it's something I've seen so many times. Somebody called to find out how much an eviction is going to cost. 3 months later, they come back now with the instruction, but now they've done the disconnection of the utility supply. They had to pay for the legal cost of that spoliation application. They had to go through all those things. And eventually 3 months later, they come back to you to do an eviction, and they've lost 3 months income. I think it's a very valid point.
Yeah, absolutely.
I mean, do you guys feel like talking about actual numbers? I mean, my own guess, Chris, and you asked the direct question, is an unopposed urgent interdict in the High Court out of hours is very unlikely to cost less than about 40 grand. It's a lot of money.
Absolutely.
Yeah.
I mean, it's
Wow.
my
50.
estimation.
About 50, yeah.
And
Yeah, 40 on
possibly
that when I feel generous.
Yeah, no, it's very hard with the time it takes, and the problem, just for people's knowledge, normally a lot of work in a process, in an eviction process, is done by support staff. But the moment you're into an urgent application, almost everything is being done by an attorney with the attendant cost, which is why the costs kick up so quickly. In an urgent application. So
Absolutely.
yeah, let's say coming to a firm that isn't one of the big firms, the prospect is an urgent application on a weekend is going to cost you between 40 and 50,000.
No, absolutely. Nothing's scaled with urgent applications. So a lot of the stuff you have to draft afresh. I used to be in urgent court, I think maybe twice a week at a stage with certain applications pursuant to sales and execution. And even then, the problem is everyone asks like, yeah, but you do it every week. So what's the cost? And the reality is one day the judge decides to stand you down till 3 o'clock that day. The other judge decides to stand you down till Friday. You've got counsel sometimes sitting in court for 2 full days just waiting for something. Urgent applications, late filing of papers, matters get delayed because now you need to go file another affidavit, or you have a stupid interim argument that leads to another argument later. The typical rules don't apply. So it is the attorneys need to think outside the box. They need to make things happen. But in the same breath, when you're in court, anything can happen, and it's a matter of being able to actually cope with it. And that's why the costs differ. I mean, take the counsels, for example, that I used to use in these applications go from between 20 to 30,000 a day. Now, 1 day versus 2 days versus 3 days, that's already 30, 60, and 90. I mean, it's you can't you can't really estimate that. It's crazy windows that you're looking at.
Yeah, no, it reminds me a lot of what my dentist told me. It's better to brush your teeth daily than to pull out rotten teeth later. A lot cheaper as well. So
the dentist is a wise man. But that's the thing. I mean, even just to expand the analogy on Silna's point, it may cost you 50 grand, but the prospect is it will cost you far more over an extended period if you don't confront it then. And the problem is so much of what we talk about cannot be avoided. You have to do it. There isn't another way. There isn't an informal way. I don't know. A lot of clients ask me, and I'm sure you as well, isn't there a better way? Isn't there another way? Isn't there a more informal way? You could get away with things years ago, 5 years ago, 2 years ago, not now. And I'm wondering, Chris, if one day we shouldn't have an actual discussion on legal costs. I've already picked up over the year or so very good ideas from both my colleagues, and maybe we need to have this debate in the open with our community, and let's talk them through, see what we come up with.
It'll be a nice video to put on our quotations. So as we're about to quote, watch this video first. So it's not just me, it's everyone. And there's our quote.
Yeah.
I'm so glad you guys say that, because I so often get, I get that, I mean, twice a week, where somebody calls and says, Silna, but can you just do a letter for me? It's just a letter. And I'm like, yeah, it's cool. It's, it's going to take me sometimes. So if you can pay me a deposit of 2,500, 3,000 rand. And they're like, for a letter. And I'm like, yeah, what you don't understand about a lawyer's job is we need to read all the contracts, all the correspondence. It doesn't take us a quick letter. The letter itself is quick. We pick up our dictaphones, dictate, your secretary types it. It's done in 10 minutes. But it's the research and the thought process where we spend 2, 3, 4 hours. So I think maybe a legal cost conversation is a good one, because I think people think lawyers just bill randomly for stuff, where actually we spend a lot of time before we answer. It looks like we're just pulling it from I must say when. But there's actually some thought process going into every single element of the things we address.
I've actually, as of sorry, Greg.
Bruno. Carry on, sir. Carry on.
So for quite a while now, I actually generally time my day, so I'm able to isolate or identify, where there's time wastages, fix it. And the reality is, like, if I look at this at the end of a given week, you're looking at like sometimes 75 hours, 90 hours of work. It's not like we're doing all this work because all this money's coming in and we just love working. That's the thing. It's every letter takes an amount of consideration. It takes an hour, even just to sit and go through the emails and find, because you get those instructions like, yeah, but I sent you the instructions, just read through them quickly. It's 12 emails, each with different subject headings coming from 2 different email addresses, then with the same threads underneath. So as you scroll down, at the bottom is the same thread from that email that he had just sent you earlier. And it's like, yeah, just read through it quickly. No, I need to print everything, put it in front of me, start throwing pages away. An hour's already gone by. I haven't actually started doing anything. But that's the thing. It's not, I don't complain. With some clients, I know that's the client. So it's like, no worries. I know you're busy. I've got a candidate attorney that'll do it for us. We work with it, right? But those clients are also the ones that understand the billing. They realize and go, great, no worries. I think the important thing is managing expectations again. I have to tell my clients, please, when you send me the instruction, do it in a nice portfolio. Like, tell me what's in there, explain to me what it's about, and you'll save yourself a fortune because you're doing that work for me. And clients appreciate that sometimes, as opposed to not setting that expectation and then them getting a bill for 5 hours because they were just not very neat in the way that they approached you.
Yeah,
exactly. Greg, you want to add?
Sure. Yeah. To continue your medical analogy, Chris, a friend of mine, also an attorney, has a doctor friend and a, I don't know, civilian friend. And the civilian said, oh, you doctors, you write a prescription and you charge $500. It takes a second. He said, no. I think. Then I write a prescription. Then I charge $500. Like, medical school and all of that goes into the weight of that prescription in the same way. In the context of what Bruno says, the letter is often the first annexure in litigation. It is so important. It's got to be right. You've got to start winning from dear sir or madam. It takes massive weight. It takes a lot of input into that little letter. And I would say, Silna, you're quite right. One of the biggest general criticisms of lawyers, he wrote me a letter and he charged 5,000 Rand for a half-page letter,
Yes.
It's the big problem. And I mean, well, there's the other lawyer analogy. Well, if I'd taken longer, I could have made it a shorter letter, so.
That's exactly. I mean, if you can resolve a matter with one letter that was supposed to go on litigation, that would have been a 2-3 year, 200,000 Rand litigation. I mean, seriously, if your lawyer is that good to pay 5,000 or 10,000 Rand for one letter, you're winning.
Yeah,
exactly.
Yeah, that's right. The other thing, and I mean, we can maybe talk about it in our cost session if we have one. Young lawyers, recently qualified lawyers, candidate attorneys, struggle to take the next step. So you get in a situation where letter. We litigators, letter, boom, court. That's the way to do it. Tell them what you want, write them a letter, demand, and if you don't get it, see what the judge says.
Take it.
This is why I love sitting with you guys on a Wednesday, because we only had 2 questions set for today, but we got 3 answers. And I didn't get billed for it.
56 minutes later.
And I didn't get billed for it. I got the bonus one for free. Thank you guys for that. To our viewers, as you can see, there's a wealth of information that comes from our 3 experts. You are so fortunate, I mean, myself included, to be privy to this information that we're getting, and it's not being billed right now. So that's the bonus. So ask your questions, join us on a Wednesday. Please feel free to drop your questions during the course of the week, or even in this video if you're watching it, and when you watch it later on after it gets put up. But for now, thank you so much for joining us. It's always a pleasure to have Bruno, Solna, Greg with us. And yeah, thank you guys. And I hope that you all have a great productive week ahead of you. And I'll see you all next week, and I'll see the viewers as well next week. Thank you, everyone. Goodbye.
Thanks.
Thank you.
Thanks, Chris. Cheers.
Bye-bye.
Cheers.